Well, hello, my friend. I am so glad to have you here again on Advocacy Arena. Folks, I have with me Marc G, a law professor, a former prosecutor, and a frequent contributor to our weekly Good Trouble chats, giving us all the legal updates. And one of the things that I learned about Marc when I first met him, and you'll soon find out, is how passionate he is about the law. So I could think of no better person to have come and talk to us, being as how in this new iteration of this regime, we have all sorts of cases swirling around. And these are monumental because I looked at them, and of course, he's gone after law firms, he's gone after institutions, he's pouring out all these EOs, which are quickly met with a lot of backlash. And I just wanted somebody to come and talk to our audience about that who could speak to it in a way that you do, Marc, because you do it so well. One of the only people I know who can speak legalese, help us to understand in such easy to grasp layman's term. So I'm going to ask you, first of all, to just say hello, and then the kind of cases and things that I had told you I wanted to dig into. So wherever you want to start from there, and I have some questions around all of them. So thank you
Well,
for being here.
D, and I know it took us a couple weeks actually to get connected here. Thank you so much again. This is like I think our second interview
Yes.
formally. I love your advocacy arena because I get to talk off the top of my head and like just go in, and I thank you for allowing me to do that and being able to communicate with folks, just stuff that I think is important, but also educate people on basics of civics and constitutional law in ways that people can understand. And I'm a law professor at heart. I teach undergrad locally, and hopefully might be at a bigger school sometime soon, but that's coming. But
Okay.
I do love teaching folks, and I like talking about these major issues that, none of us really knew were going to be major issues in law when when I went to law school almost 30 years ago. I didn't know that I'd be here with you, like breaking down these basics of con law and like, and then also discovering the arrogance of even saying basics of constitutional law because there's nothing basic about it. It's a very complex group of laws. Constitutional law is very nuanced and complex, and it's hard to understand. That's why we talk every week about the meanings of some of the things that are happening, not just with the Supreme Court, but also with some of the district court orders that are coming down. That's been coming down since we've been on Advocacy Arena since the beginning.
Yes.
I think it's very important.
Absolutely. One of the first things that I wanted to talk to you about, and especially from your perspective as a professor of law, and someone who has practiced as a prosecutor, the assault that is being carried out on these law firms. And, of course, just our institute, like kind of ignoring the courts, all of these things. Like, how do you feel about, from a lawyer's perspective, about the capitulation of some who are in the profession?
Well, that's good. I'm glad you started with the easy one first, right? Um, and some of these law firms, I know some law firms are capitulating to the president's power because they have government contracts that and money talks. Let's back up. What happened in early 2025? Trump signed executive orders that barred federal agencies from working with law firms that had challenged his policies in court. It hit major law firms like Wilmer Hale, Jenner and Block, Sussman Godfrey, and some other big, huge law firms. These are juggernauts. And the reason why he hit them is because some of them were involved in many cases that involved him as a defendant, or some of the lawyers that they hired involved him as a defendant. And so it's punishment. So who cares about big law firms, right? Nobody really cares. We should care though, because these law firms are suing the government now. Some of the good ones, like the ones that capitulated, I can't speak for them. Money talk to their partners, and partners care about their money. But
Right.
what the little law firms are arguing is that first of all, there's something called the First Amendment. Free speech and legal advocacy is protected by the First Amendment. Then there's also due process, and due process is a word that's just like being thrown around, and like people don't understand. They think it's a trial. They think it's something. They think it's like a some big thing. It's just notice of what you did wrong and the opportunity to be heard and say, I didn't do this wrong. So it's notice and opportunity, or notice in a hearing.
Mhm.
Or don't punish me without a fair hearing. And the principle that lawyers must be, and the principle is this: lawyers have to be free to represent popular and unpopular clients without government retaliation. And that's what we're talking about.
Vigorously. I mean,
Right.
you want your attorney to, represent you in that way.
Correct. And what the theme that we're going to come back to over and over in this talk is you're going to hear me say this over and over. And you probably heard me say this yesterday on Advocacy Arena, is rule of law. I was on other pods on Spoutable, which we're both on, which is run by Christopher Boozy. It's spoutable.com. Everybody should get on that. So you can hear more of D and me on Advocacy Arena on Mondays at 12. But rule of law is the cornerstone of our democracy. It's the idea that no one, not even a president, this president, can punish you for just defending someone the government doesn't like, or participating in a prosecution of a president who broke the law criminally. This is central. These cases, like this case and the other things we're going to talk about, this is central to our functioning democracy because it's an attack on our lawyers that, whether you like them or not, they're arguing law, and they're arguing before courts about rule of law. And I think that people need to understand there's a difference, because, a lot of people are disappointed by rule of law. And what I teach and what I say is that there's a difference between rule of law and also a difference between application of law, right? Rule of law says that this president committed a crime and he needs to be prosecuted. Application of law is what we have when we have Merrick Garland, who waits 2 years to appoint a special prosecutor. So we can discern from rule of law. Don't knock the message, knock the messenger. Application of the rule of law is where our problem lies, and why Trump was not held accountable in the first place.
Absolutely. And I love that you broke it down in that way because, yes, he was prosecuted. He had broken laws, but the manner and the timing of which, it was applied, the accountability was sought, led us to this moment where essentially he got off. He was able to get away with these things, and in so doing now is just running roughshod over the country and trying to do the same over the courts. And that's a very dangerous place for us to be because, as I said to you, I see three alarming dangers going on here with all of the legality of it all. And that's him attacking the rule of law, and then also trying to attack and suppress the modes of education that we, the people, have. And you always talk about us being a democratic republic, which means it is a representative government, and we get to vote to decide on those representatives. So another one of these EOs that he has passed is, targeting our elections. So I feel like he is crippling, intentionally our democratic republic, our democracy, and it just, that's it. When those things don't work, we are no longer a democracy.
Yeah, and also, um, I'm glad you brought the EOs up. Executive orders. Let's talk about, and I like to break things down. And that's why I love teaching undergrad. I don't have, like, arrogant law students like I used to be. asking what I call stupid questions now, but, like, they're not stupid questions. I
Questions
like
need
I
to
like
be
the undergrads
asked.
they're just sponges for knowledge, man. So I love the undergrads in pre-law more so than when I guest lecture at Pepperdine. I get these crazy challenges to my my academic prowess, and we lose sight of what we're talking about. But with regard to these executive orders regarding elections, let's break down what executive orders are. They're just letters, and they're not law. Executive orders are not law. The president of the United States, no matter who it is on. It has the power that is given to him by the Constitution in Article 2 or by Congress, and that's it. That's all the powers of the president. It's in the Constitution in Article 2, or there are powers that are delegated to the executive, the chief executive of the executive office by Congress. The president has no other powers. If Congress hasn't done it and the Constitution doesn't call for it, the president can't write a law. The sole arbiter of law writing belongs to Congress. Congress writes the laws from Article 1. It's the first article. The first thing that the founding fathers, if you will, wrote down is Congress. And actually, there was only one body of Congress originally. I mean, there was a great compromise, and they split it into a bicameral institution, meaning they had a Congress, a House of Representatives, and a Senate. It used to be just a Senate, but the House of Representatives were there because the South made a big deal. There's a great compromise, and that gave us the Madisonian democracy that we have, where we have a House of Representatives and we have a Senate, because at that time there were more people living in the North than in the South. They had a House of Representatives and not a Senate. They had a Senate because of the South, so that and
They could
bills
have
had to pass
the
both houses
equal.
because more people lived in the North than lived in the South. So more people, more representatives. The House of Representatives had more majority North. So that's how we got a bicameral House. And they call it bicameral. I don't know why they call it that word. That's what they call it, though. And so when they write a law, they say the president can do this under the Constitution. The president enforces and administrates the law. Enforces the law that are written by Congress, administers the law written by Congress. The judiciary, which is a co-equal branch of government, interprets the law based upon the Constitution. So they throw the law against the wall and say, hey, this is either constitutional or unconstitutional. This is not what the founding fathers had in mind. When a president writes these executive orders, like for instance the executive order regarding elections showing ID, that's just a letter. It's worthless. It's not a law. As a matter of fact, federal elections, even though there's a federal input regarding elections, each state is constitutionally responsible or has the power over its own way to administer elections. Each state can do elections in a manner that they see fit, as long as it's constitutional. They can't, like for instance, we learned in 2020, a state can't not like the results of the election and then send their own, decide if they're a majority. They want to send different electors to Congress to represent the party that lost. They can't do that. So the feds will jump in there. But the manner in which a state conducts their elections is up to the state. For instance, little things like counting ballots. The state can do hand ballots if they want, or they can do machine ballots. That's totally within the prerogative of a state. I want to get back to basics on that. So when we talk about Trump writing these executive orders, they don't mean anything, and they're gonna be challenged because I mean, what's the issue? The issue with regard to Trump is that after the 2024 election, local officials tried to block certification of election results, even though there was no evidence of fraud. Excuse me, 2020, they tried to block certification of election results, even though there was no evidence of fraud. And we see this machination of an effort to do the same thing. Election certification is not optional. It's not something that is a choice. It's a ministerial duty. And ministerial means that, like, you know what? It's not like, hey, I want salt and pepper on my eggs. It's like, the eggs come with salt and pepper. That's it. That's the only way you can get eggs in this Constitution. They come with the salt and pepper. So officials are required to sign by law, sign off on the vote counts. And also identification and things of that nature are decided locally. The president can't decide how a state does this election. And we're not going to really touch on this a lot tonight, I don't think. But this applies to federal laws too regarding immigration. We hear a lot of talk from, I call it the Ministry of Lies and Propaganda, that comes from the White House. It's a second coming of Joseph Goebbels' ideology in
Absolutely.
Nazi Germany.
We started with alternative facts from the previous one that
Started with that, and look where she ended up, that quoted it. And little did we know that we were headed here. That alternative facts are their thing. It's the Ministry of Lies and Propaganda. So we go back to that, and like we're talking about them lying about this entire process, not only the election, but lying about how the process works. And so the legal consequences, undermining our institution, our electoral institution, is election subversion. I call it election subversion because it's an attempt to overthrow valid results through pressure, delay, and refusal to follow the law. And we, like I said before in the beginning, everything from the beginning of this conversation all the way to the end of it is going to connect like a constellation. And that's how I like to look at the rule of law, as not a bunch of stars in the sky, but a constellation that makes up a picture. And when you see the picture, you understand. But when I talk about I call it data points, if you will, or star. I call them stars. This is another data point about a picture that this administration is trying to subvert our republic, and through the election laws as well, refusing to follow the law. The
They
Constitution.
have a history. Republicans have a history of this subverting of elections. I mean, like the suppression of votes and the things that they did during, the Jim Crow era. Those things are just, I feel like, that local level example. But of course, we had a civil rights march and got some of those things corrected. And it seems that what they're doing now is essentially rolling back, erasing all of that. This is just kind of a new version of that being federalized, nationalized.
Well, I mean, to that point, the Constitution requires each state to provide a Republican form of government. Now, it doesn't mean the Republicans. We are a constitutional republic. So, what that means is counting votes fairly. Everybody that can vote should vote. And then when we count them fairly. So, it's pretty simple what the founding fathers put out there. And they were able to do these votes without any big problems when sometimes it took a month to get votes back to the back to the capital. And
Right.
that's actually why they have, I mean, just a little constitutional history. Why we have the election in November and then why there's no certification till January is because it took a couple months for the carriages to get to DC to deliver the ballots.
Well, I love nerding out on some history.
Yeah, yeah. So like as the country expanded to the west, those votes were late coming in, so they had to certify those votes on January. They had to bring them, have them into DC by January 6th. Sometimes it took a month or two to get through the winter and get to DC so that the vice president could certify the vote. So that's why we have the big people are like, how come there's such a delay? After November, then we have December. Each state has to certify their election. That's federally mandated on federal elections, and then a whole nother month to get the letter, the literal electors signed in a letter under oath to DC, to the vice president for that Senate, that bicameral Senate confirmation of where House of Representatives or senatorial people can object, and they have the whole objection scenario. But that's why there's that process. But going back to the beginning, the president can't dictate in any way how a state runs its election laws, and the president can't even make a law regarding anything that's related to election law. Or president can't just make a law, period.
And as you said, these EOs that he keeps churning out, they are just letters, memorandums, but he is trying to enforce them as though they were laws. And there are some people, even in Congress and in the state houses, who are giving assist and also trying to treat them as if they are laws. How do we deal with that? Like, how does the citizenry, you know,
Well,
oppose that?
if a state actually tries to mandate some of his executive order, they'll be sued, and that'll be resolved in court rather quickly. There'll be an injunction on the executive. I mean, there might be some organizations that are suing right now once it was filed because it can't be executed. It's unconstitutional to states, and it's federally unconstitutional, most of his executive orders. This guy in the White House right now has more injunctions against him than any other president in history. Everything he does is like trying to. And let me pivot though, because I want to be careful about this to make sure that we we look at it in context.
Okay.
Trump is not doing stuff that no president ever tried to do, because every president has tried to expand upon their executive power. Obama, Bush, Biden, Bush 1, Reagan, Clinton, Carter. Every single president tries. This has been the most egregious president not following the law, though. Other presidents try, like for instance, Biden trying to expand upon his executive reach with student loans under the HEROES Act, and he got checked by the Supreme Court. Whether you agree with the Supreme Court or not, he still tried to do something that probably he couldn't do, that wasn't articulated in the HEROES Act, actually. And the Supreme Court actually even said that, like, you can't do it this way, but you could do it another way. And that
And
happens
he went
sometimes.
back around.
He went back
Okay.
around and he did it under the 78 Education Act, or 1974, 73 Education Act. So he did it under the, what's it called, the Education Act. I think it's from 73, but I could be wrong there. But he did it under that, which he always had the power to do. I actually didn't think he had the power under the HEROES Act to do it.
And
That
you
was
said that. You have mentioned that a few times. And I love that like you read the law. It's not partisan. It is the law, the rule of law, the book of laws that we were founded on. And so, I love that you take that approach when you're explaining things. It's
Yeah, I
important.
always do. And some people don't like it. And in some cases they don't like it. But I get involved in some of these cases that I just find amusing and interesting too. I don't know that they're big, but I got involved in the Tory Lanez Meg the Stallion case just because I made a comment, and someone made a comment back, and I was like, wait, no, I know what I'm talking about, because the judge in that case was my mentor. So I was able to comment on, like, I know the judge. I don't know what he was going to rule or anything like that, but I was able to give some insight into what he might be thinking and how he rules on a case. And I was pinpoint accurate because
You were. And
David
we
doesn't
talked
change.
about that in our first interview.
Yeah, I mean, he has never changed, and like, but he's one of those people that taught me to take my emotion out of law, and like that's how you win when you're in front of the court, or when you're making argument, like serious argument legally. I take my emotion out of it, unless somebody's just really stupid and they offend me. Sometimes these kids on Twitter, they're just talking mess, and they're like, what do you know? I'm like, well, actually, no, I can lecture about this. I don't want to pay Elon Musk for more space. So it's a challenge to put responses into 280 characters at one time, but I find a way to do it. Then I get on your show and talk on Advocacy Arena.
Yes, and I love it. And I think we're all made smarter by it. It is important because we are at a place and time where the electorate, our populace, the masses things have been kind of dumbed down. We are experiencing this long running, ongoing propaganda, information war, which is, as you said, the minister, propaganda is what is being fed. And if they don't have access or seek good information and accurate information, it just gets us further and further away from where I think we need to be. And I think that is one of the things that he is able to capitalize upon is the lack of understanding, the stupidity, and I just mean lack of knowledge, the ignorance of some of these people and the cult like, adherence and behavior that his base, talks, just what I'm saying.
Yeah, and one of the topics that I think you sent, and I want to talk about too, um is, I think we have to talk about this, and I touched upon it yesterday and I think the time before, and I've been talking about this honestly for what about 2 years. I've been talking about Amy Coney Barrett.
Mm,
I think that people need to start looking at Amy Coney Barrett differently, and I get laughed at a lot until the next opinion comes out, and they're like,
mm.
"Damn, Mark, you talked about that." You talked about that. I noticed something with Amy Coney Barrett, and I pay attention to the Supreme Court, not just in the not just with their opinions, but just how they interact. Like, Ginsburg was
Reading their
real.
dissents and all of this, getting an understanding of how
Not
they
even
think.
that. Not even that. Not even the written dissents, but how they engage with each other. Like
Okay.
Ginsburg and Scalia were like best friends. And you would think they hated each other when it came to Supreme Court opinions, but she pushed Antonin Scalia to be more scholarly because he had to be, because he had Justice Ginsburg there that was going to write a scathing rebuke to him. And you actually, as a constitutional scholar, you start given what we have, the Supreme Court we have now with Justice Roberts and Samuel Alito and Brett Kavanaugh and Neil Gorsuch. You start to appreciate someone you thought was your adversary, like Scalia, that was so scholarly. Reading his opinions is like reading a legal history. He made sure that even if you disliked his opinion, that he wove in the history and everything he was considering in it. And I'm not even sure he would not like the Supreme Court. I don't think Scalia would like the Supreme Court at all. He called them a bunch of morons because these conservatives are not Scalia conservatives. And the reason why, and just to pull back, the reason why I say let's take a look at Amy Coney Barrett when we talk about like our next subject, like Harvard University versus the Trump administration, because she's an originalist and she hadn't really had any judicial experience, but she actually did the welcome party for Ketanji Brown Jackson. She actually planned the party, and they have become actually friends, and their families like associate with each other. I'm not sure how closely they are, as close as Supreme Court justices can be, but
Colleagues,
they talk
who.
a lot. And
Mhm.
what you're seeing is the emergence of a different kind of judicial philosophy when it comes to procedural acts. When it comes to substance, Ketanji Brown Jackson and Amy Coney Barrett are always going to be probably miles apart. They'll argue and play with each other's words, but they're not going to be apart. But when it comes to procedural and rule of law, they're going to be right on point. Ketanji Brown Jackson herself is actually a lifetime public defender. She was never a prosecutor. Ton of legal experience. Very, very smart. And I think Amy Coney Barrett respects that because KBJ has a lot more experience. But going to my next point, there's this thing called originalism. And it's been thrown around, also called, it sometimes gets morphed into textualism. And originalism um, means or is a method of interpreting the Constitution based upon the words when they were written, in the late 18th and 19th centuries. Most of the older justices were supposed to be originalists, but they are originalist deniers and changers. But it's important though, because originalists argue that the court should not update the Constitution to match current values. That's up to Congress or state legislatures. So, under that view, if a right like abortion or same sex marriage isn't explicitly in the text of the Constitution, it's not protected. That's how we got Dobbs, right? And Barrett joined on Dobbs. That's her view of Dobbs, which overturned Roe in 2022, based on the reasoning that the Constitution never mentioned abortion and it wasn't historically protected. But then also the Constitution never mentioned privacy and it wasn't constitutionally protected either. So there's a dichotomy there. Then we have Roberts, the institutionalist, who we saw the latest iteration of Roberts in the hearing that overturned Judge Boasberg's injunction, where he said y'all didn't file this in the right place. I agree with you that the government overreached and acted unlawfully didn't turn those planes back by sending those people to CCOT in El Salvador. But even though I agree with that on substance, you didn't file in the right venue. And that's what Justice Sotomayor got her so pissed. And like, if you look at Sotomayor and Roberts' opinions, she's always pissed at Roberts about his being a stickler for the rules, even when like there's like he agrees
Nitpicking.
in substance. Roberts believes in protecting the long-term credibility of the Supreme Court. I don't know how he believes that after he's ruined it, but he's one of them dudes, and we all know people like this that are just stubborn in their own stubbornness. He tries to avoid big sweeping rulings, and he likes to narrow everything so it's just particular to that case to preserve judicial neutrality. But he runs into big problems.
That
So
hasn't worked out so well on, like for his court, for his rulings. For me as a citizen, from, a layperson.
in some cases, it has worked out though. Remember when the Affordable Care Act came before him in 2012? He was the 5-4 decision. He was like, you know what? I'm gonna uphold the Affordable Care Act because I don't love the law. But so many people will be impacted if I went the other way, and it would undermine. I think Robert said to himself, I think it would undermine my legitimacy and also the court's legitimacy. I don't know how we got Roberts in 2012 with It's called the NFIB versus Sebelius case 2012. I don't know how we went from that Roberts to the immunity Roberts in 2022, but we did. Amy Coney Barrett's view is somewhat strict and history based. Roberts is cautious and focused. And we are at the point in our constitutional republic, our pseudo democracy, where we're relying upon, at the end of the day, we're relying upon Justice Amy Coney Barrett and Chief Justice John Roberts to get us through this until we get a Congress, until we vote for a Congress that has numbers that are going to just have some common sense. Until then, they're what we got, and their philosophies matter because they shape how and whether laws are changed. Period. With a T. Period.
Love it. Having said that, you know, all of these EEOs that he's passed, brought cases, lawsuits being brought against them. When it comes to some of these major ones, like the ones around the election, given those two having the power that they have and the stance that what do I'm going to ask you to do a little prediction because I know, you like to do that kind of thing. So, how do you see those cases rising to the Supreme Court going with those two? Just imagining.
I think the Supreme Court is going to get tired of Trump and this administration and their unlawfulness. I think they already are. Judge Wilkinson out of the Fourth Circuit came out with a huge opinion. It was a 7-page behemoth, beast of an opinion that just killed the administration and begged them not to beg for this constitutional crisis because they'll and get smacked down. That's basically what he said. He's like, don't do this because you're not going to win this. Because there's people like me that respect the law, and we think that you do too because you took an oath to honor the law, respect the law, and actually the president's oath is very specific to to above all uphold the Constitution. That's his oath. He serves the Constitution and the people, and all these other people that serve him. They take an oath to the Constitution to defend the Constitution. That's in every oath. I took the oath
We
several times.
both did as veterans,
I took the oath
exactly.
as a veteran and veteran
And
and as a
law,
district attorney in 2 offices
exactly.
and federally too. So, that means something. And so what's going to happen is it's going to be devastating and embarrassing to this administration. They're already getting embarrassed on other issues that have nothing to do with law, like economics and foreign trade. This is going to be, in particular, their effort to try to dictate what schools and universities do, like Harvard. That's going to be Harvard's complaint for declaratory and injunctive relief that they just filed yesterday. It's going to be devastating to them. And like the Department of Justice, which is made up of the sycophants and the followers of Trump, most of which were his defense team, they're dumb. I don't know what schools they went to, whether they're Harvard or Yale. They're just dumb. They're dumb lawyers. And there's such a thing as dumb lawyers. They're not respected in the industry. They play this game and they're going to lose badly in this Harvard thing. Harvard is suing Trump for freezing 2.2 billion in federal research funding.
Is this the same case that because I have not dove into like I normally do a lot of the news. I've just kind of skimmed. I did hear today that like some other 150, maybe 200 more universities, smaller universities have signed on to a case
Yeah, I think
behind.
there's probably going to be a lot of universities that join because this is like a huge government versus academic freedom issue. It's a First Amendment issue. It's also a separation of powers issue. The question: can the executive or the president use funding power to punish dissent or demand ideological conformity from universities? Is that even within his power? Because he doesn't have the power of the purse. That belongs to Congress. So, but can if a university doesn't like, or if he doesn't like the way a university teaches, like if he feels like Harvard is too liberal, can he take away funding because of that? I don't think so. And like they just have all his words. Like they can just play the tape in court. I can't wait for the first hearing. I think it's going to be in the next couple of weeks because they just filed the case. I
Mhm.
would hate to be I would actually refuse if I was a part of the Department of Justice. I would refuse to defend this case and like leave it up to Pam Bondi's, her dumb associates to go into court and try to argue this.
Pretty soon she's going to be the only one who's able to go in, because when they don't argue the dumbness of, those dumb arguments, then they get reprimanded or fired, because this is where we are now.
And also think about it. If the president can dictate to Harvard what they can do, what they can teach, what stops him from doing it to media? What stops him from doing it to nonprofits? And what stops him from doing it to people, and then connect the dots? Like I said, a constellation. Connect the dots. If you don't agree with this president or with this administration, can you be shipped off too without a hearing, without notice? Opportunity equals due process. Notice, opportunity equals due process. Can you be shipped off too? So that's why the Abrego Garcia is bigger than Abrego Garcia. It's not even a gang case, actually. Yeah, I did gang prosecution. I prosecuted MS-13 too. There's nothing about this guy that says MS-13. That's just, you know.
And I love that you spoke to that in Advocacy Arena yesterday. And one of the things, again, today, I glanced and noticed that, which we knew that this was happening or would happen. There are two more recent cases in the past 7 days. One out of Arizona, the public media in Arizona reported on it. A guy in Arizona and one in Florida that both got detained. The one in Florida, I think, was only 1 day, but the Arizona one was 9 days, both legal citizens. And interestingly enough, in the government's telling of it, both of these guys admitted to being illegal, having illegally entered the country. So what are the chances of, you can just say anything, but turns out they're both American citizens. And this, I kind of reposted that story because I'm like, is this the homegrown that, he's talking about sending down there, which means any of us, like you
And
look
it's
the
so
part.
and it's so easy. Well, it's not easy. It's not easy to follow the law, but other presidents has followed the law and they deported more people than Trump has. Trump
Yeah.
actually, as a matter of fact, in March 2024, Biden deported more people than Trump did, even
And Obama had,
by following the law.
yes.
Now, remember, Obama was trying to stretch the law too. He eliminated some. Excuse me. Obama eliminated some due process. He sped up the process and he got sued by the ACLU. So we have to look at this like, immigration is not just a Trump thing. It's been a presidential thing for like the last 20 years. And there is a problem with it that Congress has not been able to deal with on the process. Because every president is trying to eliminate the amount of illegal immigration or unlawful entries that go on, and they call them contacts or engagements. Every president is trying to lessen the amount of engagements they have at the border. It's not something that's partisan, actually.
No,
But Trump, in this case, is not following the law.
right. And that's what we're going to start to wrap up here, but that's what we
Sure.
need. The problem is, like you said, all presidents have had, because it has been an issue, because there needs to be some legislation done around our immigration laws, and they just don't. They have not had the will and the ability, the makeup to do it, because, for this is my opinion, I see that the Republicans do not really want to address it except in these egregious kinds of ways, but they want to continue to be able to kind of campaign on it and to build fear and things around it. But every opportunity they're given to actually bring real redress to the issue, they're not interested.
I totally agree. And they had, well, under Biden, they had a bipartisan immigration law that would have solved a lot of the problems that they have now. But Trump put a stop to that, and because this is the kind of thing he wanted to do.
Mhm.
And maybe next time we talk more about what this is leading to,
I would love that.
because I have some insight into what is happening. But I do think that, surprise, surprise to Trump, many of his judicial appointments are actually striking some of the stuff he's doing down. And so, in his first term, he did appoint some very conservative judges, but a lot of those judges didn't go his way in 2020, and they're not going his way in 2024 either. Actually, my cousin was appointed by Trump out of the Southern District of California, and I
Wow.
I know he would not. I don't know his current cases, but I know he would not be okay with just subverting the law. He's a ruler. He's like a staunch rule of law, former prosecutor, like myself. Did some defense work at a huge white collar defense law firm, and and got appointed to the bench by Trump early on in his first term out of California. But this is egregious. The undermining of, or an attempt to undermine, what we consider our rule of law, which is the staple of our democracy. It's the pillar, rule, law. And of is the space in between. That's where the arguments are. But you have these pillars that are the foundation of where we are. And the reason why it's so important, I know we're wrapping up, so I'm kind of doing a closing too. The
Thank you.
reason why it's so important is because, as black folks, you as a black woman and me as a black man, but also with people that love the law and love the way we live and love the fact that we're under this great idea of, number one, a country of laws, number two, a more perfect union, meaning we can always be better as a
Right.
society,
It's a
but we cannot be
continuing
better.
process of perfecting it.
We cannot be better unless we got the rule of law down pat, right? We can't build upon things that are breaking our country apart. And we might have discrimination. We do have discrimination. We have racism. We have all these things, but without laws, we're not protected. Without laws, I'm not protected to go outside, because I'm pretty sure if there was no law against killing me, there's some guy out there who's a racist that would love to do so. To be that, I don't mean to be that base and that extreme, but that's a good example of why the rule of law is important. And then when we get more particular and nuanced and get granular with rule of law, it's important to hold leadership accountable to it as much as we would hold ourselves accountable to just traffic. I mean, if you imagine them holding the leadership accountable, meaning if you break the law, the Constitution steps in, the court step in. If you break the law as a criminal, you get held accountable. It's like when you drive on the freeway, when you enter the freeway, there's a scary part when you enter, when traffic is already going. How do you fit, right? That rule of law is the freeway. How people drive is the application of it. So to give you a good example of the differences. So when people say the rule of law is not working, it's not the rule of law that's not working, because the freeway is there. It's the application of it. If you come on too aggressively and you don't yield, there's going to be a problem. If someone doesn't yield to you and y'all going the same speed and you're trying to merge, you're going to crash.
Exactly.
That's application. That's not the rule of law. So it's a good way to look at it. And also, it's the people, the cars that say, hey, I'm going to slow down and let you in because I'm going too fast and I can see in 200 feet, we're not going to make it. I'm slow down, let you in. That's application of the rule of law, and it works, right? So that's the way we need to keep going. There's always going to be disagreements between myself and my conservative counterparts, and myself and my more progressive counterparts when it comes to a bunch of things. I just got in a big debate about homelessness yesterday, but the one thing that we have in common is that we want to preserve some middle ground here, a fulcrum of justice. And unfortunately, we're at an imbalance on that fulcrum right now. And we need to get that balance back so that we can actually make real arguments that are substantive with regard to how we move forward on policy, and not worried about, presidents and a whole administration breaking the rules and breaking the law.
I love it. And I think that is a good note for us to wrap up on. And we will plan our next discussion, because I do think that with this administration, we're going to be meeting and talking about the law a lot. So, you're always welcome, of course, in our weekly Good Trouble chats. And like I said, I do think it's important that maybe we start to make a regular appointment here to, kind of, give people updates of what's going on and break it down to them. So thank you
Yeah,
so much for being
of
here
course.
with me.
I love that. Yeah.
All right. Well, you have a good rest of the evening, and we'll look forward to picking back up the next time and see what's percolating then that we need to stay focused on and, or bring people's attention to. Thank you for listening to Connections and Conversations. This is one of many wonderful interviews that we bring to you to help connect you to a larger community of advocates and changemakers across the country. You'll get a glimpse into the various ways people are making an impact in their communities. My hope is that it will inspire you to get engaged in some small way as well. We can't all do everything, but at this moment in history, we can all do something. What are you doing? One of the things you can do is to continue to listen, subscribe, and share this Advocacy Arena podcast. You can also join and support the growing grassroots Advocacy Arena community in other ways. Join our weekly live chats hosted on Spoutable every Monday at 12 p.m. Eastern. Subscribe to our Substack to get great articles on important topics and exclusive access to extended interview conversations. And don't forget to subscribe to our YouTube channel as well. We've got some exciting programming lined up. And keep listening to our regular podcast episodes wherever you get your podcasts. And of course, subscribe and give us that all-important 5-star review.